Hello and welcome to another episode of Luxury Redefined with Dr. Nermeen. I'm your host, Dr. Nermeen. This is the podcast where we explore how luxury is being reimagined through culture, strategy, and creativity. In today's episode, we're stepping into a less visible but incredibly powerful side of luxury, the law. Because when we talk about exclusivity and luxury, we're not just talking about craftsmanship or scarcity, we're also talking about legal ownership. For example, who gets to protect an idea, a design, even a cultural symbol? And what happens when brands push those boundaries? To help us unpack these questions, I'm joined by Geraldine Blanche, a lawyer and researcher at Sciences Po, whose work focuses on fashion law, intellectual property, and cultural heritage. She's also been involved with the Bibliothèque Nationale de France, diving deep into how the law intersects with fashion, history, and creativity, and global influence. Geraldine has also been teaching intellectual property law and management in fashion and luxury for the past decade at Sciences Po and Parsons Paris. Together we explore how legal frameworks shape luxury, from protecting, innovating, to navigating cultural appropriation, and why these issues matter more than ever in today's globalized world. It's a fascinating conversation that blends law, fashion, and power, and I promise it will make you look at fashion with a sharper, more informed eye. Let's get started. Geraldine, I'm so excited to have you with us on the podcast. Welcome. It's the first time that we're going to be discussing the legal and intellectual property aspect of luxury. To start us off, can you please tell us a little bit about your journey into fashion and law and why the intersection of luxury, creativity, and the legal system has actually captivated you?
Well, first of all, thank you so much for this invitation. I'm thrilled that I'm the first one talking about these issues with you on the podcast. I always like to say that I'm really lucky to be working in intellectual property because it's a very easy aspect of law to get easily into and interested by. So, I mean, as far as I'm concerned, half of the work was already done for me. I came to be, so I'm an intellectual property lawyer, and I was dealing with all sorts of intellectual property issues, mainly copyright, industrial design, and trademarks. I'm less of a patent person, but I was working in all manners, and so all types of industries. It came to be it's one of those life moments that kind of happens upon you. Someone I was chatting to one day said, "Oh, we're really looking for a lawyer to teach in one of our fashion management programs. We'd like to see if maybe it could be a good fit of a type of class or topic." And obviously I'd had a few fashion cases and lots of luxury cases, but I came through it more through the fashion lens, and I wasn't necessarily a massive expert on fashion. I knew the legal aspects of it, but less the managerial aspects of it. And I started, oh yeah, that's a nice challenge. So I started teaching the class, and obviously you build your schedule, and you build your syllabus, and you build all your documentation. And I realized there was so much to do. And I started teaching, and I absolutely loved it. I mainly teach to master's students, at a master's level. So really students who are very much already a step at the foot, or who have already engaged in a professional life. And so they really come to me not to be lawyers, but really to understand how they can use the law in a managerial aspect. And I started teaching, and I just loved it. I loved that as a lawyer, I got to discuss these issues with future practitioners or previous practitioners. and I felt a lot less pressure than when I have my purely lawyering hat on, and I have to finish a case, and there's the strategy and there's the urgency of it. It allowed me to give myself a little bit more time to fully understand. And to be a good lawyer, I really appreciate teaching. So I've been teaching for the past 10 to 12 years now, and I don't want to stop. And it really started just because I had that class that I needed to give and teach. And I delved into obviously management theory. I delved into fashion history, the law, intersection of intellectual property law, how it started, where did it start, why did it start, I spent a lot of time in archives, and I still do. So really, that's kind of the story. It all kind of met because I was asked to teach, and I wouldn't look back for a second. I love the fact that it is very transdisciplinary. So I go from, as I said, history, law, sociology, marketing. There's a fair amount of psychology too, if you think about trademarks and the value of something, the worth you attach to something, if it's considered luxury or not, why. And I love it. I just keep learning. So yeah.
Fascinating. I love the story. You seem to be quite passionate about the teaching side, and for the students, how lucky are they to have someone who has practiced, not just theory. I'm so curious to know something. To you, as Geraldine, as an intellectual property lawyer, what does luxury actually mean to you?
That is such a good question. Because my definition of it is quite flexible. And over the past 10 years, I've learned to not attach myself to one definition, because the definition of luxury is so entrenched in so many different criteria. I mean, geopolitics could have an impact on what one defines as luxury. And as such, it's very difficult for me to, let's look at it from today, my perspective today. When I think of luxury, I think of it as an industry. And like any industry, it has interests, and it has that it needs to defend. And that's more of a lawyering perspective, I guess. But these past few months, that's the perspective that I've been, because of my work that I've been in. And sometimes there are other moments where, I don't know, sometimes I just need to, I'm based in Paris, and there are many fantastic exhibits. And I just visit, a fashion exhibit, for example, and I'll come out of there with my eyes popping out of the sheer beauty and craftsmanship. And all of a sudden, luxury will take much more of a definition around rarity, time, craftsmanship, and a more like hand-driven industry. So I don't like to bog myself down with one definition, because as a lawyer, it tends to give me a few blind spots. And if I am working with clients, I'd rather understand what their version of luxury is, and what their interests, depending on that definition, is at a given time, to see if I can defend it as best as I can. Sorry, I can't give you a precise definition, but I enjoy, and I think it's important for me to not have one specific definition, but to understand it and get the cues from people to see what is important to them. What do they define as luxury? And I mean, it depends on your time of your life. Maybe at one point in your life, luxury is going to be time. And another point in time, it's appreciating calm. At another time, it might be something that goes, I don't know, the luxury of a car, because you appreciate the speed at that time in your life. Who knows?
Yes, that definitely shifts over time. I mean, for the same person throughout their phases in their life, but also possibly across cultures, maybe, across eras. What was luxury in the 18th, 19th, 20th century is different. And that kind of makes me think. So has intellectual property law evolved with that? How has it changed?
Absolutely. Absolutely. I'm going to take the example of fashion. One of the questions when I started doing research was when did intellectual property and fashion meet and why? And I started looking at the birth of what we now call haute couture, which started in France in the middle of the 19th century. And I delved into archives of case law and like very old books with a lot of dust on them that I uncovered really genuinely in archives. And it dawned upon me that with the birth of haute couture, so the father of haute couture is known as a British gentleman called Charles Frederick Worth, who actually moved to Paris in the mid 19th century and who shifted things around, because what he did was he said, well, if you wanted a dress made and you had, good means to have a really nice dress made, you would buy your fabric, go to a tailor or a dressmaker and say what you wanted with that fabric. And so most of the decision making was in the hands of the consumer. And Charles Frederick Worth, long story short, kind of turned that on its head and said, no, I'm going to decide, I'm going to create, and people have the liberty of following or not. And so he created the fashion cycle and that very kind of top-down system at the beginning. By doing so, and he firmly believed this, he said he wasn't an artisan anymore. He became an artist. And that was something that seeped into society in the 19th century. But in law, it took a while, basically, for intellectual property law to say, well, you know what? Well, copyright protects artistic works, but painting, sculptures, maybe. But fashion, no. It's just like, what you wear. It's utilitarian. It's definitely not artistic in any shape or form. And so it took a lot of case law, a lot of very subtle yet very strategic management and lobbying, and over the course of 60 years, approximately 70 years, and then one day a French court said yes, it actually is considered artistic. And it's when haute couture had finally been beautifully crystallized with a whole array of designers. So this was in the 1920s, in between the two world wars, but it took a long time. And so all that to say is that very often law is a reflection of what goes on in society. And so intellectual property law will come to protect something that society recognizes as artistic. The same issue happened with photography at a given time. A lot of photographers said, well, we want to protect, we should have copyright. And courts initially said, no, it's mechanic. What are you talking about? How artistic can it be? You're just taking a snapshot of something. But yes, but I arranged the snapshot. So intellectual property law, if you look at it through the lens of fashion, I think it's a nice example. And the birth of haute couture and this really beautifully crafted, well thought of high luxury, just by the sheer amount of time and personification that there is in a garment. It took a long time for intellectual property law to kind of recognize that. And actually, France is at the forefront of protection, because in France there was this very strong industry that was built around the luxury industry and around fashion in the 19th century. There came a point where, very prosaically, the French government was, well, this is a good export material and we're starting to get copied around the world. So how about we actually extend copyright protection and maybe other forms of intellectual property right to these designers? So yeah, and to this day, and to be fair, that's what makes my work also very fascinating, is that law isn't harmonized around countries. You can have countries that seemingly have the same economic systems and don't have the same systems and the same cultures of law at all. So to this day in the United States, copyright does not protect fashion designs. So it's free to copy fashion designs in the US. And because courts have consistently said, no, it's utilitarian. But historically, the American fashion industry was built on copying European designs. So of course they weren't going to protect it with intellectual property, and it remains to this day. And so law is a fascinating concept in a very globalized world because it's still very country specific. Even if you have harmonized, treaties that harmonize in Europe, where I am, there's a lot of harmonization with the European Union. The European Union comes up with treaties and directives and regulations. That's great. But then don't forget, there are also courts who are going to have an interpretation. And you might have a judge in Italy who says, I don't know, a hairstyle is not artistic and should not be protected. And in another country, a judge may say, oh, definitely, it is artistic and can be protected. So depending on the country where you are, you have different legal rules that apply, which makes it fascinating because it reflects the cultures of countries and how they approach a specific aspect of luxury. Going back to the question of definition.
Wow, so many things going through my mind right now. So the same global brand could face very different decisions across the world. So even if it's a French brand, just because it's global and it operates in the United States, it might have a very different ruling. So actually brands are not that well protected, right? So where does the reach of IP actually stop in that case?
You're asking a fabulous question because you are absolutely right. When you have a company that is present in multiple countries, yes, you need to be aware of what rights you have, what obligations you have, and how what works in one country might not apply in another country at all. And the example of copyright protection between France and the US, which people would say, oh, well, they're very Western countries, they've got the same systems and the same types of economies. Not at all the same. So this is where it gets into a very interesting area of intellectual property, at least for me, which has to do with strategy and how law is really a strategic tool that you can use and harness. Now, intellectual property isn't just one thing. It's a toolbox. You have a lot of different types of tools. You have copyright, you have patents for inventions, you have trademarks for brands and logos, you have industrial design, you have a whole array of tools. So depending on what you want to protect, you're going to use one tool or another or multiple ones that you can stack, and you create your intellectual property portfolio. One intellectual property right, which to me is the most interesting, particularly when it comes to luxury, is the trademark, because the trademark protects the brand. So I always like to ask this question to my students: what's the difference between a trademark and a brand? Because they're used synonymously all the time. And a trademark is a legal title of property. It's your title of property that says, I own this and I have an exclusive right on this. And the brand is the marketing concept that comes along with it. But they refer to two different sciences, if you will, but they're often used synonymously. So I like to differentiate the two, though. And the trademark, basically, as long as you register it, you can pretty much register a trademark pretty much anywhere around the world, and you can have that legal title of property anywhere around the world. So if you take, I don't know, LVMH and their entire portfolio of trademarks, they can register their trademarks in the US, they can register their trademarks in France, they can register it, I don't know, Malaysia, you name it, and it's protected there. And why do you think that historically a company like Louis Vuitton splashed the LV all over, and this is historical, this is well known, all over their products when they started doing luggage and travel goods, because they didn't want to be copied. And if you're dealing with counterfeiting, a trademark is a great way to go, because as long as you protect it, you make sure you register it, you can have a much more widespread protection.